My name is Charles Lincoln. I'll be presenting the Kerckhaert Morres case based off the European Union Court of Justice case in regards to broader broader policy implications. Now, the facts of the Kerckhaert Morres case are pretty simple. You have a couple living in Belgium, and they receive in 1995 and 1996 dividends from a French company. France imposes a withholding tax of 15%. Belgium does not apply the credit system for any taxes paid through on French withholding taxes to dividends. The Belgian tax dividends at 25% on the corporate level without any double tax relief for the withholding tax. Thus, they paid more tax in the dividends for the incoming Belgian company. Now, this is the scenario. You had the gross dividends. You had there you go. You had gross dividends. So you have the Belgian domestic under Belgian domestic law. Normally, you get 25% tax, corporate income tax, and then the tax burden is only 250. So that's 750, right? But then let's say you have so it's treated differently. Here's the scenario of a Belgian domestic tax and the foreign French. So those are dividends received within Belgium. On this side, you see that in France you have a French withholding tax 15%, 150, and then you have income tax on the 850 in Belgium, with a 25% is 212.5, and then you add those two together, and you have 150 plus 221, so you have double tax with no credit relief. Now, the procedural posture of the case was that the Belgian court requested a preliminary hearing from the European Court of Justice on whether this imposition of double taxation violated Article 53 of the Treaty on Fundamental Freedoms, as if it imposed a restriction on trade. And from the incoming legislatives, if Article 53 could be interpreted as prohibiting restriction resulting from provision of income tax legislation of a member state. The Commission stated, the Commission stated before the case was decided, that the ECJ should not force Belgium to give a tax credit because it would be a violation of EU fundamental freedoms. The Advocate General's view was that juridical double taxation was a quasi-restriction, and it may only be eliminated through intervention by a community legislature. The ECJ basically followed this by stating the treaty freedoms do not preclude member states from exercise of parallel taxing jurisdiction, even if it leads to double taxation, so long as neither state treats the cross-border situation less favorably in the domestic situation. This is not a restriction on the free movement of capital. Now, the Terra Vatel book stated that the comparability standard is needed to decide whether two positions of comparable form point of view object. The comparability standard is needed to decide whether the two positions are comparable from the point of view of the object and purpose of the impunged tax measure. The assumption of the taxing jurisdiction is national sovereignty, but the exercise of the jurisdiction so assumed is subject to court scrutiny. Basically, Terra Vatel stated that the court realized there was an issue, but it took Montesquieu's advice and did not speak this French quote from the bench. Now, compare this to the Comptroller of Treasury of Maryland versus Wynne. The court reasoned that the tax schemes failed the internal consistency test because cross-border taxation was disadvantaged, and this violated the Commerce Clause. But instead attributed the court reasoned that the tax schemes that fail the internal consistency test will fall into one of the first categories, not the second. Any cross-border disadvantages remains after the application of the test, but is instead attributable to the taxing the state's discriminatory policies alone. Here's the Commerce Clause of the U.S. Constitution. Basically, Congress can govern interstate commerce. So commerce among the states. Now, the Maryland tax system was two-tiered. On one level, you had the state income tax, and on another level, you had the county income tax. The state income tax credited for other state income. The county tax did not provide credits for those other taxes. Now, the wines were gaining income from dividends from Utah, and they were subjected to tax in Utah, and then they were taxed on the statewide level and the county level in Maryland, but they were not provided any double tax relief in Maryland on the county level. Justice Alito provided a two-pronged test that stated Maryland's tax needed to be internally consistent, and in addressing the internal consistency, the court needed to examine Maryland's personal income tax scheme as a whole. The court found that the test found has been in 7 U.S. Supreme Court cases. It asked whether interstate commerce would be taxed equally if every state were to adopt the price tax scheme at issue. Maryland's tax failed the test. Because if every state adopted this test, then if every state adopted this test, then there would be double taxation resounding throughout the union. Now, so the court reasoned that unfavorable treatment of interstate commerce was not simply the American scheme, but inherent in the tax system. As such, the scheme operated as a tariff, and it discriminated against interstate commerce. Now, there were dissenting opinions as well, and interestingly, it was an ideological diversity amongst the dissenting opinions. Justice Scalia and Justice Thomas wrote the Dermis Commerce Clause as a judicial fraud. Although Justice Scalia said it was a judicial fraud, he said he would still apply it under stare decisis since it has been applied 7 times. Justice Ginsburg argued that she argued that the Maryland tax did not violate the rules, and she contended that Maryland's tax was distinct from those previously invalidated on internal consistency grounds because those were imposed on natural persons who are state residents. And court's response to Ginsburg was that Justice Ginsburg was confusing the requirements of due process and the Commerce Clause. Court agreed Maryland, like any, had the power to impose worldwide taxation, but did not mean that any tax imposed pursuant to the jurisdiction was consistent with the Commerce Clause. So the open questions are: did for the wine cases, the court did not state how Maryland should solve the problem. They used a credit method for the wines. The court could provide other solutions as well. Some final thoughts: just like in the wine case, the court did not legislate from the bench. So should the European Union adopt an internal consistency test, perhaps possible through legislative amendment through a Commerce Clause? Maybe. So some solutions could be: the Commission's idea is use treaties which determine double tax relief. The legislature creates a European framework for dividing taxing rights, or the ECJ could try to place the blame on a state to relieve double taxation. The ECJ could try to place the blame on a state to relieve double taxation, perhaps reference to OECD principles. Yeah. New Deal for Europe. Maybe CCTB could solve this issue as well if it was expanded to